I want to welcome you all to Washington Legal Foundation's annual Supreme Court end of the term briefing. This is the 28th year that we've been doing this, believe it or not. I've not been here for all those years, but pretty close. I'm Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are each and every year a very active participant as an amicus in the Supreme Court. We filed in 9 merits cases this term. We're on the prevailing side on 7 of them. We're certainly very proud of our successes there. We've also filed a number of amicus briefs in support of cert. There are some materials downstairs for those of you who are here in person, and I can share it with anyone who would like it online about some of the cases we've filed cert support in, one involving medical device preemption, the Stenkel case, and one involving EPA regulation of greenhouse gases, which has a number of different petitioners in that one. And it's a very interesting term, this term in general, I think. It's a term filled, I have to mention this, with some really quirky and interesting opinions and seemingly a battle of literary and cultural references flying around between some of the justices. You had Scalia wielding the Jeremy Bentham panopticon prison concept, and Justice Kagan had her reference to Clue the musical the other day, and she even had a veiled Tommy Two-Tone reference with a phone number in an opinion a couple of weeks ago. So we're definitely looking forward to hearing what the speakers have to say today about the free enterprise-oriented cases that we'll be addressing. And I want to hand over the baton to our Legal Policy Advisory Board Chairman, the Honorable Dick Thornburgh, who's counsel at the K&L Gates Law Firm. Dick?
Thank you, Glenn. You have obviously established yourself as the color man in this presentation. You're delving into some of these paths, but I want to add my welcome to those of you who are here and those of you joining us by podcast. Of course, we're here to discuss matters, as Glenn described, within the purview of the interest of the Washington Legal Foundation. We're not unmindful of the fact that the primary focus of today and tomorrow and the rest of the week will be on the so-called social cases yet to be decided. Nonetheless, there are a number of significant cases of interest to the business community, to which Washington Legal Foundation for the last 36 years, I think, is the age of the process, has carried the banner for free enterprise through aggressive advocacy, thoughtful scholarship, and programs designed to educate us all about the advantages of free market principles, limited and accountable government, individual rights, civil liberties, and legal ethics. That's a pretty broad mandate. One of the most popular programs that WLF has put on now for, as Glenn said, 28 years are these periodic reviews of Supreme Court cases, now available through a wider audience through our webcam capability. Today, as usual, we gathered a panel of experts to discuss cases decided during the tail end of the term, and I'm going to introduce them in the order in which they will make their presentations. Neal Katyal is a partner at Hogan and Lovells, a former acting Solicitor General, a former clerk for Justice Breyer, and also now teaches at Georgetown Law School. He is to my immediate left. To my right is Ashley Parrish from King & Spalding, member of what is styled one of the top appellate groups in the U.S., former clerk for Judge Emilio Garza in the Fifth Circuit. And a familiar face to my far right is Eric Grannon of White & Case, who has a focus on antitrust activities, and most important, is a member of the Washington Legal Foundation Legal Policy Advisory Board. Each of these folks, in the order I indicated, will present for 20 minutes or so, and then we'll follow that up with some discussion and questions from those of you who are both here and on the internet. So thanks for joining us. I'll turn it over to you, Neal.
Thank you very much. It's a real delight to be here with all of you. The Washington Legal Foundation is really one of the preeminent Supreme Court advocacy organizations. And so it's a real privilege to talk to you about two Supreme Court cases. That's all I'm going to do, is talk to you about two. And before I do that, I did want to say it's also a real privilege to be here with General Thornburgh. I say this with all sincerity. I just left the department fairly recently. There is no Attorney General who I think is more beloved than Attorney General Thornburgh. I mean, in terms of the independence and in terms of the creativity and what he brought to the job, I mean, people talk about it constantly, and so it's a real honor. It's the first time I've gotten to meet him, and so I'm glad to be here for that reason as well. So I'm going to talk about only two cases, and the first one is Kiobel versus Royal Dutch Petroleum. And I should say in both cases I had interests. In this case I represented the U.S. Chamber of Commerce, so take what I say with that in mind. This is a case that involves a really old statute. The statute comes from 1790, is part of the First Judiciary Act, and it grants courts jurisdiction, quote, over any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. Well, if you know what that means, you're ahead of the game, because nobody else seems to. And indeed, for almost 200 years, the statute lay fallow, and no one was doing anything with it. Judge Friendly once called it a kind of legal mystery. What is the statute even about? Well, in 1980, in a case called Filartiga, the Second Circuit breathed life into the statute and said that it might be able to be used for various human rights violations. And so, well, that was one thing. That case involved, serious human rights abuses and so on. The statute was then picked up by plaintiffs' lawyers who started to use it to attack corporations that they argued had aided and abetted human rights abuses abroad. And this became a very serious problem for the business community, with dozens of suits against the Fortune 500 companies, some involving damage requests of $400 billion and the like, and extensive discovery that was having to take place abroad, and it was a significant concern to the business community. So this particular case, I think, exemplifies those issues pretty well, those problems. So you had 12 Nigerian nationals who claimed that that Royal Dutch Shell, this company headquartered in London and in Amsterdam, had propped up the Nigerian military regime in the early 1990s during Shell's oil exploration time, and sought damages on the basis of that human rights abuse. The Second Circuit held that corporations were immune from liability under the Alien Tort Statute because they were not natural persons. And the Supreme Court, when asked to consider that on certiorari, agreed. And so they granted certiorari now, almost 2 years ago, on the question, is a corporation liable under the Alien Tort Statute? And briefing took place, and then there was an oral argument in, I think, probably November, about a year and a half ago. And at the oral argument, Paul Hoffman, the attorney for the plaintiffs, was asked almost right off the bat by Justice Alito, and I should say as an aside, Justice Alito, in my mind, is really becoming kind of the kind of most tough questioner. He doesn't ask many questions, but boy, the questions he asks are really, really good. And so he asks, as the first question of the argument, or maybe it might have been the second, says to the lawyer, let me read to you the first line of your petition. The first line of your petition is 12 Nigerian nationals are suing Royal Dutch Shell, a British and Dutch company, for human rights abuses taking place in Nigeria from 1990 to 1995. And he says, what possible business, Mr. Hoffman, does this claim have to do with the United States court system? And Mr. Hoffman, I wouldn't say had a particularly compelling answer to that question. And no knock on him. It's probably pretty hard to give an answer to that question. And the result of that was right after the oral argument, the court ordered re-argument on the question, does the Alien Tort Statute apply extraterritorially? And so you had a whole new round of briefing. And the briefing took place on that question. And ultimately, the Supreme Court recently decided that the Alien Tort Statute does not create extraterritorial liability. And so it was a win for Royal Dutch Shell. The majority opinion was written by the Chief, joined by Justices Scalia, Kennedy, Thomas, and Alito. And it did begin by not saying, we're not answering the corporate liability question. It's still open in other cases to the extent it could ever come up. But what they did say is that there is a presumption against extraterritorial applications in statutes, and that applies to the Alien Tort Statute, and that nothing in the text, the history, or purpose of the statute can overcome the presumption. They said that the presumption against extraterritorial application of United States statutes provides that, quote, when a statute gives no clear indication of an extraterritorial application, it has none. And the court said that that canon reflects the presumption that United States law governs domestically but does not rule the world. And so the court went on from taking that baseline presumption, a presumption that they had, I think, given a lot of life to 2 years ago in the 10b-5 securities case of Morrison, and said it applies just as much to the Alien Tort Statute. That there's nothing in the text or history of the statute to indicate that it should apply abroad. They said that to apply it abroad might create international strife. They said foreign countries ranging from Papua New Guinea to Canada have protested the United States' exercise of jurisdiction over foreign companies for conduct that took place outside the United States. There were some concurrences, the most significant of which was written by Justice Kennedy, who said this was a limited holding, that it leaves a number of significant questions unanswered. In particular, he said that the extraterritorial reach of other statutes, such as the Torture Victims Protection Act, need to be judged down the road. And he said that, quote, cases may arise with allegations of serious violations of international law principles protecting persons, cases covered neither by the Torture Victims Protection Act nor by the reasoning and holding of today's case. There was a separate concurrence filed by Justice Alito, who said that he would just make sure that this was clearly all extraterritorial and barred. And then there was a a complicated concurrence filed by Justice Breyer, who said that in this particular conduct, in this particular case, the case didn't implicate a uniquely American interest, but he could envision other cases in which they would. And the bottom line question is, or the bottom line holding is that this case really does effectively close the door to a large amount of the Alien Tort Statute litigation that had been filed against United States companies. Yes, it has left open some limited grounds, and the plaintiffs' community, ever since the decision, has been celebrating those. But I think that the best reaction to this decision was the one written by Human Rights First on the day of the decision, a centrist human rights group, which said, quote, today in its decision in Katyal versus Royal Dutch Petroleum, the Supreme Court gutted the Alien Tort Statute. And I do think effectively that that's right. It is extremely hard, given both Katyal and the earlier Supreme Court decisions in Iqbal and Twombly, which require particularized allegations at the pleading stage, for plaintiffs to survive. Yes, there are some limited, narrow ways in which they might, with respect to alleging United States-centered conduct by corporations or something like that. But the court has, I think, left a very strong signal that that type of conduct, that in general, the massive litigation that we've been seeing, we should not expect to see in the future. The second case I want to talk about is a case called Myriad Genetics versus Patent and Trademark Office and others. Of all the cases I've ever worked on in my life, this is the case that I think has been the most interesting. That includes Bush versus Gore and the Gitmo cases and the rest. This case involves the question, can the human genome be patented? And Section 101 of the Patent Act provides that certain things are patent-eligible subject matter. And in particular, it must be, quote, a new and useful composition of matter. A new and useful composition of matter. And the specific facts of this case involve the BRCA1 and BRCA2 genes. These are genes that were discovered by Myriad Genetics almost 20 years ago. And if you have these genes in your body, you have an extremely high chance of getting an aggressive and, if left untreated, fatal form of breast cancer, roughly 85% chance. These are long nucleotide sequences that occur in people's bodies naturally. And in Myriad Genetics discovered those code sequences. Another group found the same sequences a few weeks later. Both were funded largely, as I understand, by the NIH. But nonetheless, Myriad got it first. They filed a patent and said, we now own those sequences. And so whenever anyone would like to take a test to see do they have these genes in their body, they take a simple blood test, which it costs a nominal amount, but Myriad has been charging roughly $3,300 for the royalty of running what is in your body against the gene sequence code that it has, that it found and discovered in 1990. And so the question in the case is, if someone discovers something, a gene sequence, which undoubtedly required lots of human ingenuity, sweat, effort, intelligence, and the like, is that a new and useful composition? The Supreme Court has said in a series of cases that products of nature are not new and useful compositions. So you can't just patent a leaf or something like that. You can't patent E equals MC squared. Those are fundamental building blocks of human knowledge. And what Myriad said here is, well, we're different. See, we're isolating out a specific segment. It doesn't occur otherwise in nature. It's not the leaf itself. We're only patenting a piece of the leaf, essentially. We're patenting this little sequence that isn't obvious to the ordinary person. It required lots and lots of knowledge of genetics and the like. And the other side, the ACLU, which brought the lawsuit, said, no, it's part of human biology. It's in your DNA. You didn't invent anything, Myriad. You simply you simply just filed a patent on something that already exists in nature. The case came to me when I was at the Justice Department at the Court of Appeals stage. The Patent and Trademark Office has issued thousands of patents on genes since the Reagan administration, and I was a failed pre-med and unfortunately not really equipped to really understand this. And so I spent every Monday for a long time at the NIH every Monday night, and other times, whenever I could squeeze it in, getting tutored by all these Nobel Prize winners and others about genetics. And then I spent some time with economists and others to try and understand incentives for innovation before making this decision, which was probably the most extensively thought out decision that I made in the office because there were so many competing interests at stake. But ultimately, I said that it seemed to me that if you're simply discovering a gene sequence, that is a product of nature. That is something that isn't patent-eligible subject matter. However, Myriad was also doing other things. They were creating cDNAs. They were manipulating the DNA to make something that had never before existed. And I said, if that's the patent claim, that part will be patent-eligible. And ultimately, the Supreme Court decided a couple weeks ago that was the position unanimously to uphold, that the human genome by itself, if it literally exists in your body, that isn't patent-eligible subject matter. But to the extent that you're manipulating the DNA to create something new, that isn't a product of nature and very well may be patent-eligible subject matter. The Supreme Court didn't fully reach that second question because it wasn't teed up, I think, but I think they've given some pretty strong indications that if they had to reach it, they would reach it in a favorable way. So with that, I think I will turn it over to General Thornburgh and our next speaker.
All right, I'm the traffic cop here. You're up next, I think. Ashley,
Right.
go to it.
Okay. Thank you to the Washington Legal Foundation for inviting me to participate, and it's a real privilege to be here with you and the other speakers on this panel. This afternoon, my comments want to focus on the recent trend in the Supreme Court on specifically administrative law cases and what you might describe as an increased focus on the sense that there's a need to discipline expansive or aggressive assertions of agency or government regulatory authority. Because unlike Neal, I'm not going to be just descriptive, but at least a little provocative and maybe even controversial. I'm not going to discuss any of the cases that I was directly involved in, but instead what I'd like to do is really focus on 3 points. First, I want to talk about what I think is an interesting and clearly unusual interactions that occurred early this term between the Solicitor General's office and the court itself. Second, I'd like to try to connect those interactions to a discussion of these administrative law cases that we are seeing increasingly appear on the court's docket, and specifically talk about one of perhaps the most under-discussed but most important cases of the term, which is the City of Arlington case. And then lastly, in terms of predicting how the court might think about administrative law cases going forward and the types of things we might see coming out of the court, I'd like to connect that to some of the preemption cases that were decided this term and draw some connections between that and how preemption has been handled. So let me start with talking about the Solicitor General. As everyone sort of knows, historically there's this idea that the Solicitor General is the 10th Justice. There is no doubt that the Solicitor General's office has remarkable influence over both the makeup of the court's docket, but also the way in which cases are decided. It has a lot of respect. And despite what I'm going to say here, it continues to have great influence and great respect. So I want to make sure that my statements in terms of picking up on something isn't sort of an overstatement of what I think is happening in the court. Nonetheless, having said that, I think this term was very unusual for the tensions that seemed to emerge very publicly between the justices and the Solicitor General, and really clearly at the start of the term, and my sense is that towards the end of the term a lot of this subsided. To give you a few examples, a lot of people noted in November, Justice Alito gave a talk to the Federalist Society here in town where he was very direct and some would say unguarded in his criticisms of the government for taking very expansive positions in terms of assertions of government authority, and mentioned a few cases where the court had, in unanimous 9-0 decisions, struck that down. The best example, I think, of that from last term is the EPA versus Sackett case, which had to do with the question as to whether or not if you were subject to extensive fines for building on what had been designated as a wetland, did you have to wait until the fines mounted, or could you actually go into court and challenge that assessment? That was a very important case, and the court in a 9-0 decision said, no, you actually can challenge it, you don't have to wait, and rejected the government's position on that. Alito had mentioned that, but he also mentioned some other cases, and I think the general reporting and reaction to his speech was that it was sort of unusual how direct he had been about the interactions with the SG's office. There were also early in the term a number of oral arguments, and I'm going to mention sort of 4 cases. Neal mentioned the first of these, which is the Katyal case. Very interesting when it was re-argued. I think there was a real sense that the government and the Solicitor General's office did not want to be in the case in the way that it had been reframed for the second argument. And so there appeared to be palpable tension at the oral argument between the justices and the Solicitor General over the question of, please give us some direction as to how you think this case should be decided for future cases, or what should the rule be. And the Solicitor General was very reluctant to do anything other than try to convince the court to make this a one-time, one-off decision. And if you read the transcript, listen to the transcript, or if you were in the court, it was quite interesting as to how aggressive the justices were and how, I think, frustrated they were that the SG was not performing more of that role of being the 10th Justice. Then there was the U.S. Airways versus McCutcheon case. This was argued in November 27. Neal, I think, may have been involved in this case. It's an ERISA case, so I'm not even going to attempt to explain what the case is about.
I argued it, and it was boring. So.
Yeah. But there was a very interesting exchange, again, that revolved around a footnote in the government's brief. It wasn't even really central to the case, but there had been a footnote about how the Secretary of Labor had upon, and I think the words were something like further reflection, changed her mind as to what the regulations should require. And it turns out that what had actually happened was that there had been a change of administration within the new administration. The Secretary had taken a different position. And the Chief Justice was very upset at the SG's office and asked some pointed questions that even said, wouldn't it be more candid for you to actually tell us that there actually was a change of administration? Then the next case that really came to attention to court watchers was the Gabelli versus SEC case, which was argued in early January. For those in the courtroom, this was one of the most sort of uncomfortable positions an assistant SG has ever been in. It's a friend of mine, so I felt terrible for him. But it was a very difficult argument where essentially in that case the question came as to whether or not for bringing enforcement action by the SEC for claims of fraud or securities fraud, does the statute of limitations run from the time of the fraud or from the time of discovery? And the SEC was advancing a relatively new position, supported by some lower court cases, but that it should take place from the time of discovery, not the time of the fraud itself. And Justice Breyer, then joined by Justice Scalia, the Chief Justice, and I think almost everyone piled on at one point or another, kept asking the SG's office to name one case that would support their position, that would explain this, expansive assertion of authority. And of course, there wasn't a case that the SG's position was that sort of the issues were in equipoise, but it was clear that the court was not very happy with the government's position in this case, and it later came down to a 9-0 decision against the government. And then lastly, there was the Decker versus Northwest Environmental Defense case, which is an important administrative law case for some of the questions raised by the concurrence and dissent relating to deference given to the agency. But again, there was another very tense exchange at argument, because the argument happened on a Monday, and on the Friday, EPA issued a new amendment to their regulation that attempted to basically moot out the case. And the court, Chief Justice Roberts, again, was quite upset, not only that nobody had been sort of alerted about this, but even though it seemed like the rule was rushed to come out just before the argument, the court was given no sort of heads up by the SG's office. So, and then lastly, apart from those oral arguments, I think another thing that for people who are involved in the court was really quite extraordinary was a supplemental brief that was filed by Roy Engler. This was in the American Trucking versus Los Angeles Los Angeles County case, which involved a question where the court had called for the views of the Solicitor General, and the Solicitor General in its brief had suggested that the court should not take cert and should not review the case. And the supplemental brief filed by Mr. Engler and his firm was really scathing in its criticism of the SG, and basically said, they never find a case that is worthy of cert. Their arguments in this case are really meritless, and you shouldn't trust the SG at all. You should grant review. If you read the case, read the brief, it is really quite remarkable for how direct and aggressive and hard-hitting it is against the Solicitor General's office and the idea that the court should not give them any deference on their views. And in fact, the court did grant review in that case. So I guess the question is there any explanation for this dynamic and what's going on? And I do think there are some interesting explanations that tie into the cases themselves. But I want to again sort of go back and emphasize that a lot of these tensions appear to have subsided, and there's a danger of reading far too much into what really are isolated, although I think unusual incidents. With that said, I do think there are some sort of broad themes that are important for any of us who practice in front of the court. One is I think that there is a changing docket that's been well recognized in the SG's office as something that's been going on for the last 15 years. But increasingly, the SG is a reluctant participant in Supreme Court cases insofar as it is not asking the court to grant review. It is not looking to push cases up to the Supreme Court. Instead, it is overwhelmingly participating as amicus in cases that otherwise get to the court and it has a view on. In some ways, you can see that goes contrary to the idea that it's going to serve purely in the role of a 10th justice. Second, there have been these increasing assertions of government authority. For those of us who practice in the lower courts, what the Supreme Court is seeing is only the tip of the iceberg. But for the Supreme Court, these really seem like outrageous assertions of authority, thinking about the Sackett case and then a number of other cases I'll mention briefly today. And I think that the government's response to many of these cases has been a traditional response, supported in the case law, but essentially one of trust us, we should take maximum discretion. And I don't think many of the justices, and perhaps none of the justices, actually believe that that is the right approach to take. Second, I think the Solicitor General's office has arguably lost some credibility in this area. In many cases, there's a sense that the Solicitor General is serving as a sort of a partisan actor. And this, I think, is particularly true in some of these traditional business-type cases that would usually not be very controversial, but would be more interesting legal issues where there is a sense that politics is coming into play. And then lastly, what I think may be the biggest explanation, which I think is an innocent explanation but is also an important one, which is the internal decision-making process of the office itself. There is a long-standing tradition that as long as there is a reasonable argument to be made in support of a government's position that has been taken by the agencies below, then that argument should be made. And in most of these cases, in part because of the deference that's given to the agencies, there are many reasonable arguments to be made. The arguments that the government is advancing in these cases are not, in sense, doctrinally absurd. They're not without basis. But if you step back and think about it for a while, some of the cases, the end result is really absurd. And I think what's happening is that the court, being a little further removed, is seeing the absurd end result and not getting caught up in the intricacies of how you get there. So turning from those comments about what I think has been an unusual term in terms of those interactions, I want to say just a few words about the administrative law cases, and I put these in sort of two boxes. Obviously, we can't talk about all the cases this morning, but there's, in the first box, which I think are cases very much like the Sackett decision that we saw from last term, which is where the court is basically slapping the government down in unanimous decisions for overreaching. Two of these cases, one is the Arkansas Game and Fishing Commission case. That was an 8-0 decision because Justice Kagan was recused. That was argued in October and then decided in December. But essentially the question is, if you've got a dam that the federal government controls and it floods the lands below the dam, and it does that only intermittently, does that ever constitute a taking? And basically what had happened here is that the state agency was trying to grow trees on its land, where the federal government was more interested in helping out the farmers who wanted to grow crops, and they would flood the lands and make it very difficult for the state agency to actually produce these trees. And the Solicitor General and the government had made the argument that there was basically a categorical bar on, you can never have a taking under these circumstances. And the court rejected that and said, no, that can't be right. It has to be, it is open to a takings claim and it has to be considered on the merits. That was another case where at the argument, I think several of the justices were somewhat incredulous at the government because the government, again, was taking us a sort of a trust us, we have deference in this area approach, and the court was having none of it. Another case that was recently decided only a few weeks ago was the Horn versus Department of Agriculture case. That's a Thomas opinion, again 9-0, and that relates to regulations of raisin growers. And the question there was, somebody who didn't want to be subject to that regulation and didn't want to have to pay fees. That typically when you grow raisins, if you're a handler, someone who processes raisins, you're supposed to take a large portion of those raisins and put them in a reserve, and you have to pay assessments to the government. And one question was, if they wanted to object to that on takings grounds, did they have to file a separate lawsuit in the Court of Federal Claims, or could they, as a defense to an enforcement action, raise it in district court? And again, the government's position there was that, no, you needed to file a separate action and that the enforcement action could go forward with no question about the takings issues. And that was, again, struck down, and I think echoing in small part what happened in the Sackett decision, which is that we're going to make sure that the courts are available to parties that want to challenge these assertions of agency authority. That takes us to sort of a case that I think sort of says, well, even though the court is very aware of these problems that are occurring in administrative law and the need for further direction, will it be able to provide that direction? And I think the key case there is the City of Arlington. A very interesting case. Again, with all deference to the attorneys involved, the facts don't matter, but it was a big win for the government. And the case raises a very important legal question, which is an agency entitled to deference in interpreting the scope of its own jurisdiction? Interesting decision with Justice Scalia writing the majority decision, Justice Breyer writing a concurring opinion, and then Chief Justice Roberts joined by Justices Alito and Kennedy writing the dissent. And I think, as everyone will know who's listening into this, under long-standing Supreme Court precedent, there's the Chevron doctrine. When you take a look at an agency's interpretation of a statute, you first look, is the language plain? And then second, if it's not plain, is the agency's interpretation of the ambiguous language reasonable? The question was, does that apply to jurisdictional questions? Justice Scalia, in a very powerful opinion, says yes, it absolutely does. And the idea that you can try to distinguish between jurisdictional and non-jurisdictional questions for administrative lawmaking doesn't make any sense. There's no way that you can do that except for on an arbitrary basis, and Chevron applies to everything. It's a very strong decision, and it was a very powerful response to the dissent because it really pointed out a hole in the dissent, which is how do you actually apply this? If you think there's something important about disciplining agencies on jurisdictional questions, it's not clear how you can do that in the Chevron framework. And in fact, Justice Scalia says, I secretly suspect that those who are criticizing Chevron, what they want to really do is get rid of the doctrine altogether. Chief Justice Roberts' dissent doesn't go that far, but it is also a very powerful dissent, and he begins by noting the massive rise in the administrative state over the last 15 years with 50 new agencies. And quoting Justice Scalia from another opinion, he notes it would be a bit much to describe the result as, quote, the very definition of tyranny, but we still need to be careful when we take a look at aggressive assertions of administrative authority. He gives a very powerful explanation as the separation of powers, why it makes no sense to have the agencies interpreting their own jurisdiction. and therefore he dissents. But interestingly, he really doesn't have an answer to Justice Scalia's point, which is how do you go ahead and apply it? And I think, and what I'd like to suggest, is that this is the biggest challenge that the court has in its administrative law cases and will continue to have, which is that there is a problem right now, which is that during the last 20, 30 years, an administrative law doctrine has been developed that has been very successful in disciplining assertions of judicial imperialism and allowing for agency expertise to be heard through the judiciary and to have effect in cases. But that doctrine in some ways has outlived its usefulness. Not that it doesn't still need to be there, but that nobody really that litigates in the courts today is worried about judicial imperialism on questions of administrative authority. They're much more worried about the courts deferring to agencies who are exercising aggressive assertions of authority. So the question is, can the court actually come up with the types of doctrines it will need and the new doctrines it needs in order to address this area of the law? And I think it's very difficult to do that, in part because of what I mentioned earlier, in the sense of the natural tension between the Solicitor General's office and the court in this area of the law. I think another interesting point is that in the past, the court has often looked to administrative law scholars or scholars in various different areas to provide guidance, and it's not clear, and in fact there have been a few cases, Keobel is a good example of this, where there seems to have also been a disconnect between the current members of the court and the academy more broadly. That takes me to perhaps the bad news of why I'd like to connect this to preemption, because I do think that although the court is looking very seriously at interesting issues of agency deference, that we have the risk that this area of law might go the way of preemption. And I do that by talking about there were 5 important preemption cases this term. I won't go into detail of all of them. But the thing about the 5 preemption cases that I think underscores is that the court could arguably and maybe uncharitably be said to deciding the preemption issues by going through the U.S. Code on a statute by statute, provision by provision basis. There's very hard to predict in any particular case whether something is preempted or not, but instead it seems like in each case the court engages in very detailed statutory interpretation, looks at the facts, and then makes its own judgment. But it really doesn't give much direction to the lower courts or the parties involved as to when preemption will actually occur. So real quickly, because I think I'm almost out of time here, although Glenn, please wave if I'm exceeding my time. Perhaps the most important case was decided yesterday. That was the Mutual Pharmaceutical Company case versus Bartlett. This is sort of an interesting case that extends the court's earlier PLEPA decision, which had preempted state failure to warn claims against generic manufacturers. And what it does, it extends that now to design defect claims. And it's an interesting opinion that I think is worth reading for a whole lot of reasons. Justice Alito writes the majority decision. Justice Sotomayor dissents. It's an interesting case because it's just horrific facts about somebody who basically takes something that seems a little stronger than aspirin for pain relief and ends up being terribly disfigured and disabled as a result of a side effect reaction. And the question is whether the state law could actually come in to give her a cause of action. And the majority says no. And the interesting point is that what both the dissent, I think, and the majority recognize is that there are really only 3 options for the manufacturing company. One is they could change the design or the label of the drug. 2, they could stop selling it altogether and just exit the market. Or 3, they could pay compensation as a cost of doing business. And I think what the majority says in its opinion is, look, the first 2 options are precluded because of what the FDA does and see our PLEPA decision. Those are clearly preempted. And we're not going to admit that stop selling or paying compensation as a cost of doing business is an appropriate part of the analysis for purposes of preemption analysis. I happen to be very sympathetic to that position just on my own views, but it's interesting from the dissent's perspective where they attack that very strongly and say, no, that can't be right at all. This is very different from PLEPA, and that as long as there's an option to get out of the market or there's an option to pay compensation as a cost of doing business, then there should be no preemption. I think given the tensions between the courts, the justices on the court, you will see these types of issues continue to percolate up. There's the interesting WS Secretary of North Carolina versus EMA, which is basically the initials of a child. This is an opinion with Justice Kennedy and then with Roberts dissenting. This relates to the federal Medicaid statute and whether it preempts a North Carolina statute that requires an across-the-board 1/3 payment to the state of any tort judgment or settlement that is recovered to reimburse the state for payments made for medical treatment. So what basically happens is somebody sues they receive a settlement, and some of that portion of that settlement relates to medical treatment, it's okay for that portion of the funds to be given to the state to reimburse it. But the federal law says anything else that's recovered that's unrelated to medical treatment, the state has no right to claim that, and that's preempted. And so the question in this case was the across-the-board 1/3 payment rule, was that reasonable and that was appropriate? And the majority says no, it's not. And basically you have to do a case-by-case analysis to determine what exactly portion of the settlement relates to medical treatment and what doesn't. And the dissent says this is crazy, we're really intruding on the state's legitimate rights here. What is interesting in this case, again, is that there is also, as in the other case, an interesting background principles that are coming into play, which is how much do you defer to the agency for purposes of preemption, which takes us back to the administrative cases, which in the sense, although the court is reluctant to defer to the agency in some circumstances, in other cases it's looking to the government for some direction. I'm not going to go through the rest of the cases. There are two interesting cases in the Federal Aviation Administration Authorization Act, one that finds preemption and one that does not. And there's another case called Hillman versus Moretta, which also finds preemption. So there's lots out there for preemption. The only thing I would say, which might be controversial and others with more knowledge can disagree, is I just don't see any way of connecting these cases other than the fact that the court tends to look at the express preemption provision, engage in some statutory analysis, and then occasionally smuggle in some concepts of conflict preemption through the back door to explain how the preemption is actually working. So I guess in terms of going through that quick review, what I think is interesting will be, and what we should all be watching, is whether the court over the next few terms will be able to provide greater guidance in these administrative law cases that are very, very important, or whether we're going to see that the differences in views among the justices splinter out into something more like the preemption cases, where we see the cases being decided on a one-off by one-off basis. And then let me close by just making one perhaps other controversial, a pet peeve of mine, but as long as I have the podium, let me say this. At every one of these Supreme Court wrap-ups, particularly within the media, there seems to be a body of folks out there that like to talk about how this court has a pro-business bias. Let me just say I reject that. I don't think it's a very helpful way of looking at the court. And one way why I want to emphasize that is because it ties back into my comments about the Solicitor General. If you were to actually take a look at the statistics, the Solicitor General wins 66% of the cases in which the government is involved in, but nobody would be crazy enough to say that this court has a pro-government bias when it decides its cases. What's going on here is much more nuanced issues about how to apply the law on a case-by-case basis. And although I've drawn some really broad brushstrokes here, which I think have some truth to them, I think nothing takes away from actually taking a look at the specific case, looking at the specific doctrines that are involved and the ways in which those doctrines are being developed by the court and being argued by the litigants. With that, I'll close and thank you for letting me talk today.
Thanks, Ashley. You'll find no argument within the Washington Legal Foundation about that conclusion, I'm sure. Eric, you're our cleanup hitter. See if you can hit it out of the ballpark here, my friend.
No pressure at all. Thank you, Governor Thornburgh and Glenn and everyone else at WLF for inviting me. I'm Eric Grannon, a partner here in White & Case in the Washington, D.C. office. And I'm going to focus on two principal areas today. The first is the court's recent 5-3 decision in Federal Trade Commission v. Activists, which concerns so-called reverse payment settlements of pharmaceutical patent litigation. That decision resolved a circuit split on what my friend Roy Englert described at this very podium a few months ago during WLF's midterm wrap-up as the hardest question in antitrust law today. And Roy's description seems to have been borne out in the court's 5-3 split, with Justice Breyer writing for the majority and the Chief Justice writing a vigorous dissent joined by Justices Scalia and Thomas. Justice Alito was recused. And I'll try to whet your appetites a bit by noting that this is Justice Breyer's first antitrust decision that has ever drawn more than a single dissenting justice. And this is also the first time that the Chief Justice Roberts has authored the dissent in an antitrust case. So I should give the disclaimer, I guess, that my motivations in making that kind of observation are not entirely academic. I was the counsel of record for two of the respondents in the case, and our favorable Court of Appeals decision was reversed and remanded. My second topic will be the court's two decisions this term concerning class action arbitration. These are the most recent in a string of 4 decisions on class arbitration that the court has issued within the last 3 years, and there may yet be room for another decision on the issue down the road. Now, on the class arbitration issue, I'll give the additional disclaimer that I successfully represented petitioners in the first of the court's class arbitration decisions, Stolt-Nielsen v. Animal Feeds, in 2010. So I'll start with FTC v. Activists, which requires a bit of table setting because of the fairly unique context of pharmaceutical patent litigation between brand and generic companies under what is known as the Hatch-Waxman Act. Congress passed Hatch-Waxman in 1984 to encourage the development of generic drugs. And the Act provides that if a generic company makes a so-called Paragraph 4 certification under the Act that the generic's product does not infringe the innovator's patent or that the innovator's patent is invalid, then the generic can piggyback on the clinical safety and efficacy studies performed by the innovator, which usually take years and are very expensive. So by virtue of that piggybacking, the generic can come to market much sooner, assuming that the generic can, in fact, defeat the brand's patent case. Now, this Paragraph 4 certification is unique to the Hatch-Waxman Act and the litigations thereunder and constitutes, quote, an artificial, constructive act of infringement, close quote, that allows there to be a case or controversy for purposes of Article III jurisdiction over the patent litigation when, remember, the generic has not actually marketed any product that could infringe the patent. It's only filed a piece of paper saying that it could do so. So Congress designed this constructive infringement to make it easier for generics to test patents without having to risk the treble damages that would follow any actual marketing of a product that actually infringed the brand's patent. Now, the result is that generics can make this Paragraph 4 certification, and the only thing they risk is losing the patent case. There are no damages if the generic loses the patent suit, so the only consequence to an incorrect Paragraph 4 certification is whatever the generic spent on that litigation. And, of course, if the brand wins the patent suit and it's upheld, the innovator doesn't get any attorney's fees and there are no damages because there was no actual infringement. So it's because of these somewhat complex asymmetries of risk between the brand and generic companies in these Hatch-Waxman litigations that there began to be settlements of Hatch-Waxman pharma settlements that had never occurred before that act was passed. And in those settlements, the brand and generic would typically agree to permit the generic to enter the market with its generic copy of the brand's product sometime prior to patent expiration. And in some of these settlements, the parties would also enter into contemporaneous business transactions at the same time as the settlement. Now, in a reverse payment case, a third-party antitrust plaintiff alleges that the settlement of that litigation between the brand and the generic amounts to a collusive arrangement in which the brand company is paying the generic to settle the patent case and stay off of the market with the generic's copy of the brand's product. So, for example, if a brand company has 10 years left on its patent and the brand is in patent litigation with the generic, the companies might decide to split the baby and let the generic in 5 years prior to patent expiration. Now, the settlements that attracted scrutiny from the Federal Trade Commission and the class action bar were those in which the companies also did some contemporaneous business. Any so-called side deal that paid the generic any money was susceptible to being attacked as, quote, a payment for delay. The FTC's theory being that absent the payment, absent that, quote, side deal, the generic necessarily would have gotten an earlier settlement entry date. So for over a decade now, such reverse payment claims largely failed in the courts under the so-called scope of the patent test that had been adopted by the 2nd, 11th, and Federal Circuits and numerous district courts. Now, the circuits following that scope of the patent test held that as long as any settlement does not contain restrictions outside the scope of the patent, there is no antitrust violation. So basically, as long as the settlement does not extend the patent term temporally or restrain products that are not at issue in the patent litigation, the settlement was viewed as within the nominal bounds of the patent and legal regardless of any contemporaneous exchange of value. So again, for about a decade, there was this kind of glass half empty, glass half full difference in perspective between the FTC and the courts, with the FTC saying that any settlement that didn't provide for immediate generic entry was one of delay, and if there was a contemporaneous business transaction, that was pay for delay. And the courts applying the scope of the patent test said, no, as long as the entry occurs before the expiration of the patent term, you're okay under the antitrust laws. Along comes the Third Circuit last summer in a decision written by Justice Sloboder that was the first to adopt the FTC's view of these settlements, holding that any transfer of value from the brand to the generic contemporaneous with settlement of one of these Hatch-Waxman patent cases constitutes a presumptive antitrust violation under the so-called quick look mode of antitrust analysis. And that mode had been advocated by the FTC, by the private plaintiffs in that case, and an amicus brief filed by the United States in that case. And then, of course, that was the position that the United States took in the Supreme Court in this matter. And I should note, kind of apropos of Ashley's comments before about Katyal, that the United States expressly switched its position in this case from 3 prior responses to CBSGs that it had filed on the issue during the Bush administration. So in any event, that Third Circuit decision teed up the circuit conflict between the scope of the patent test and the quick look presumptive antitrust violation. And the Supreme Court's decision 1 week ago today expressly rejected both of those tests in favor of a third approach, which is kind of a classic judicial baby split, namely a less structured application of the rule of reason, focusing on whether there were, quote, large unexplained payments, close quote, to the generic, or instead whether any transfer of value could be explained as a fair market value transaction, or in the case of more modest net payments, attempts by the brand company to settle for an amount below its anticipated future litigation costs. Now, the majority was emphatic that, quote, sometimes reverse payment settlements can be anti-competitive, using the word sometimes 6 times in the majority opinion. And because we had prevailed in the case on a motion to dismiss against the FTC, the case had to be remanded. Now, the majority gave 5 reasons for rejecting both of the tests that had percolated up in the circuit courts. First, the court held that, quote, the payment in effect amounts to a purchase by the patentee of the exclusive right to sell its product, a right it already claims but would lose if the patent litigation were to continue and the patent were held invalid or not infringed by the generic product. Second, the court reasoned that where one of these payments occurs, if it reflects so-called traditional settlement considerations, such as avoided litigation costs or fair value for services, there's not the same kind of concern that the patentee is using its monopoly profits to avoid the risk of patent invalidation or finding non-infringement. So it said that for that reason, the FTC's proposed presumptive violation of the antitrust laws wasn't appropriate. And the court went on to say that there were other potential justifications for a transfer of value. Now, third, just briefly, the court said that large payments could be an indicator of market power on the part of the brand patent holder. Fourth, the court rejected the contention that a rule of reason analysis would necessarily lead to kind of retrials of the patent merits within the antitrust case. And on this important point, the court said, quote, it is normally not necessary to litigate patent validity to answer the antitrust question. An unexplained large reverse payment itself would not normally suggest that the patentee has serious doubts about would normally suggest that the patentee has serious doubts about the patent survival, close quote. And then the final reason was that the court's rule, in its view, would not interfere with legitimate settlements of these litigations. Now, the Chief Justice, again, in his first authored dissent in an antitrust case, was emphatic in his 18-page dissent, nearly as long as the majority opinion itself, that the scope of the patent test that had been followed by the majority of the circuits was the right approach. And there he said, quote, our cases have made very clear that patent settlements, and for that matter, any agreements relating to patents, are subject to antitrust scrutiny if they confer benefits beyond the scope of the patent. The majority points to no case where a patent settlement was subject to antitrust scrutiny merely because the validity of the patent was uncertain. Not one. It is remarkable, he said, and surely worth something that in the 123 years since the Sherman Act was passed, we have never let antitrust law cross that Rubicon. And in addition to remanding my case, the court just yesterday GVR'd the petition that had been held from the Third Circuit's decision that was pending. Now, I think the key in advocating to courts and advising clients under this new activist rule is going to be when that, quote, sometimes that the majority referred to 6 times is established. And the court's guidance is emphatic that the primary concern is large unexplained payments. In that respect, the decision from the court last week kind of puts us back to where we were before all of these scope of the patent cases, where the first of these reverse payment cases were brought by the FTC, and we had an administrative trial before the FTC's ALJ that lasted for 40 days, and we actually won that trial on the valuation of the side deals, which demonstrated that there was no anti-competitive effect from the settlement. So I think that going forward under this new rule, brand companies and generic companies will have to get smarter about making contemporaneous demonstrations of fair market value of any side deals that they have, whether in the form of a third-party valuation opinion or even holding hearings before the patent judge and having findings made and enshrined in a consent decree. Now, because the activist decision is so grounded in all that table setting I gave, with the Hatch-Waxman Act, I think it's hard to predict, whether there could be any, unintended applications in other areas of patent law or antitrust law. But even on its own terms, activists affects countless patent litigations that are in the courts now and that will be filed and how they may or may not settle, as well as scores of antitrust cases already in the pipeline and that may be filed under this new standard. So it's clear that activists is definitely one of the most important business cases this term. Now, I had a cheat sheet here just to put activists briefly in context of some of the other IP cases this term. Again, activists was a 5-3 decision. Some of the court's other IP cases this term, the Monsanto decision held unanimously that a farmer in a case could not reproduce a genetically modified seed without Monsanto's permission, a unanimous decision. The very complicated myriad human gene case that Neal addressed before, unanimous decision. A case called Already, where the court held unanimously that Nike's unconditional and irrevocable covenant not to enforce a trademark against a competitor mooted that competitor's attempt to invalidate the mark. And then another notable case, the Kurtzsang decision, wasn't unanimous, but it was 6-3 in holding that the first sale doctrine under copyright law bars a copyright holder who licenses a copy of the product abroad from then seeking to ban that copy from the United States as so-called gray market goods. So a much more comfortable majority in that case. So I think it is, demonstrably true that activists was, the thinnest majority of any IP case this term and the most controversial IP decision of the term. So with that, I'll turn briefly to the class arbitration cases, which don't require nearly as much table setting. There are basically 3 governing principles that run through these 4 cases that the court has issued on class action arbitration since 2010. And the first principle is that under the Federal Arbitration Act, arbitration is always a matter of consent as expressed in the parties' arbitration agreement. It's never a matter of coercion as occurs in litigation. The second principle, to ensure that parties' arbitration agreements are enforced enforced to the same extent as any other matters of private contract, the FAA preempts any state law that purports to treat the terms of an arbitration agreement differently than other forms of private contract. And that type of preemption is necessary as a protection against the historical judicial hostility toward arbitration that the FAA sought to overturn. And the third principle is that as a byproduct of the consensual basis of arbitration, there are extremely limited bases for judicial review of arbitrators' decisions as long as those decisions purport to be based on construing the parties' arbitration agreement. So in other words, courts will not save parties from their own consent to arbitrate, even if the arbitrator's decision is likely erroneous on the merits, as long as the arbitrator does not exceed the scope of the authority granted to him or her in the parties' agreement. Now, the best way to address the class arbitration decisions this term, and there were 2 of them, is to start actually with the first one that was issued in 2010. And in that decision, Stolt-Nielsen v. Animal Fields, we prevailed in the Supreme Court defeating claims for class action arbitration, primarily on the basis that the 2 sides in the case had stipulated that the relevant arbitration agreements were literally silent regarding the parties' intentions as to class arbitration. But the arbitration panel in that case nonetheless imposed class arbitration essentially as a policy preference, as the most fair and efficient way to resolve the antitrust claims at issue. And in a 5-3 decision written by Justice Alito with Justice Sotomayor recused, the court vacated that arbitral award allowing class arbitration. And the court held, quote, "A party may not be compelled under the FAA to submit to class arbitration unless there is a contractual basis for concluding that the party agreed to do so," close quote. And that contractual basis was plainly lacking in that case due to the party stipulation that the agreement was actually silent. 1 year to the day after Stolt-Nielsen, on April 27th in 2011, the court decided AT&T Mobility v. Concepcion, which held in a 5-4 decision written by Justice Scalia that the FAA, the Federal Arbitration Act, preempted California state law that had been handed down by the California Supreme Court that declared unconscionable any arbitration agreement that prohibits class action arbitration. And the majority in Concepcion held that the California rule singled out arbitration agreements as opposed to applying generally to parties' private contracts, and that was the basis for the preemption. There was no issue about deferring to arbitrators in Concepcion because the parties' agreement expressly prohibited class arbitration, so the only issue was the preemption issue. Now, the court's 2 class arbitration decisions this term really are just straightforward applications of Stolt-Nielsen and Concepcion. First, the court held in a unanimous decision written by Justice Kagan in Oxford Health Plans v. Sutter that an arbitration defendant could not seek to vacate a class arbitration decision under the FAA after submitting the issue to be decided by the arbitrator as a matter of interpretation of the party's contract. And the court distinguished the stipulation that was present in the Stolt-Nielsen case, the stipulation as to silence of the agreement, and said, reasoning that an arbitrator must have a contractual basis for imposing class arbitration, not necessarily a correct one. Now, the court's rationale there was that, again, because of the extremely limited bases for judicial review and vacatur of arbitral decisions under the FAA, that kind of the price of arbitration is that when you agree to it, you agree that the arbitrator may make a mistake and that you're not going to have judicial review. Again, as long as that mistake is something that is grounded in a purported interpretation of the party's arbitration agreement, the FAA provides very little remedy. 10 days after Oxford Health, the court decided the American Express v. Italian Colors restaurant decision, holding in a 5-3 decision written by Justice Scalia with Justice Sotomayor recused, that a contractual waiver of class arbitration is enforceable under the FAA even when the plaintiff's costs of individually arbitrating a federal statutory claim would be prohibitive given the potential recovery. Now, that's a bit of a mouthful, but to explain, unlike Concepcion, the Amex v. Italian Colors decision didn't have anything to do with the FAA preempting state law hostile to arbitration. Amex is a set of federal antitrust claims, and the plaintiffs argued that they could not effectively vindicate their statutory antitrust rights without class arbitration because in a normal bilateral arbitration between just one of the restaurants and Amex, none of the restaurants would have enough at stake in the arbitration to take on all the costs that it would take to prove the claim, including hiring experts and that kind of thing. Now, Justice Kagan's very vigorous dissent in that case colorfully characterized the majority's response to this kind of infeasibility of bringing these negative value claims as, quote, too darn bad. That's how she thought that the court dealt with that circumstance. Now, the scenario that the court has yet to face regarding class arbitration and could be a potential decision down the road is when there is an arbitration agreement that is arguably silent as the class arbitration, but there's no stipulation to that effect, and on the basis of the arguable silence, one side in the case refuses to submit the class arbitrability question to the arbitrator, instead contending that the question is a gateway issue of arbitrability that must be decided by a court under the FAA, and it would be very interesting to see how that would come out. So I'd say just more broadly that there's been kind of a clear majority of the court recently that has repeatedly been skeptical about relaxing requirements for either class arbitration or class actions generally, and that this may continue going forward. Next term, we're counsel in a case granted on the removability standard for state court actions to federal court under the Class Action Fairness Act. So with that, I will turn it over to Governor Thornburgh and Glenn to MC any tough questions that you guys may have for us.
Thanks very much, Eric. The award for murkiness, I think, goes to arbitrability these days, and we all better brush up on that. It looks like it's coming at us pretty hard. Glenn, do you have any questions from the... Okay. Any table talk that any of you want to comment on what your colleagues have said? I might be interested in, Neal, your reaction to the commentary on the solicitor's office.
Okay. I'm not going to comment on my successor, who's done a really good job. But I guess it might be helpful to just set the stage for, the way I approached the office was I was guided by two precepts. One was the idea that the views of the United States generally do not change from one administration to the next. Sometimes the inputs to the Office of the Solicitor General change because agencies are, after all, political heads. And so you have different memos coming in and different policy positions taken. The HHS and education departments will have different views. And so the inputs come in. But generally, the interests don't change. And I said at the beginning that it was a real honor to be here with General Thornburgh, but that's what he stood for. That's the fundamental principle that he took as Attorney General, and in some ways it's even more important as Solicitor General because you're not just engaged in a conversation with the public, you're engaged in a sacred conversation between you're the chief courtroom official for the executive branch and for the Congress, and you're in this conversation with the third branch and their highest court in the land. And so you have